Any mention?
Yes.
May I please, Your Lordship? I beg to mention item number 8, Lordship.
He's on the other side.
No objection, Your Lordship.
What is that? What is your prayer?
Up to 2 weeks, Lordship. After vacation, Lordship.
Okay. On the prayer of the petitioner. List after 2 weeks. Yes.
Much obliged, Lordship.
May I please, Your Lordship? Your Lordship, I would like to make a mention of item number 9, 10, and 11, Your Lordship. It's a connected matter, Your Lordship. I humbly pray,
Yes,
Your
no
Lordship,
objection.
kindly this matter may be listed after vacation, Your Lordship.
This is on the prayer of the petitioner. List after 2 weeks. Yes. All right.
May I please, Your Lordship? Beg to mention item number 6 and 7. Both are connected matter. We are the newly pleaded respondent in this matter, Your Lordship.
Yes.
So we need to file some affidavits. So we need some time.
Yes.
Therefore, I humbly pray, Your Lordship, please to take up this
Yeah, please,
matter
Your
after
Lordship.
vacation.
Yes.
Lordship, I'm appearing on behalf of Dr. P. Agarwal for the petitioner in
Yes.
item number 7.
Your Lordships, I am appearing for petitioner in item number 6, Your Lordships.
You just record their name. Any objection to the prayer made?
No, Your Lordships, in any case,
Newly pleaded, Your
There's
Lordship.
an
Lordship.
interim order in your favor, isn't it? Okay, just
Let the matter come as a vacation, Your Lordship.
okay on prayer made.
Deeply obliged.
Newly respondent. Wait. Let us see. Newly respondent number. Your respondent number?
3 and 4.
In both the matters.
Yes.
Okay. Prayer made on the newly impressed not 3 and 4. The 3 weeks time is granted for filing affidavit position.
Deeply obliged.
Yes.
obliged.
May it please, Your Lordship, I beg to mention item number 16, my lord. Conducting counsel Ms. B. Kongthao is indisposed. Matter may kindly be taken up after a week, ma'am.
After item 16,
Item 16, ma'am.
you are for the
And for the petitioners. This is a quashing application.
this Rahman Ali.
Rahman Ali, yes.
Yes, you'll go after vacation then.
No objection, Your Lordship.
Any kind of interim order here? No.
No, Your Lordship.
Okay, on the prayer of the petitioner, list after vacation. Yes.
To the cause list, item number 1.
My lord, here I pray for only 1 week time, lordship, to have the instruction, lordship. I am yet to receive the instruction, lordship. I had to talk with the OC as well as the IO. 1 week, lordship.
Sir, Sheikh Leonard Ji. Declaring for the state, place for ungranted. Further 1 week's time for taking instruction. Taking
Master.
instruction.
Item number 2.
Wait, please, Lordship. Lordship, I appeal for the respondent. I will be filing my objections in the course of the day, Lordship. The matter may be fixed for hearing. It's a civil revision against the arbitrary.
Your objection will be
Please, Your Lordships, I am appearing for the petitioner.
By way of the last order, we were allowed to file objections insofar as the
okay in the miss case.
in the
Order
miss
is
case,
passed in
Lordship.
miss case.
So that may be read as objections in the main case also, Lordship. Lordship had passed an interim order.
Yes. You have submission is that you have filed already your objection. MS E. Dakhar. See your last 1411 order of 1411.
Lordship. Lordship, yes, I'm sorry. I'm so sorry. Yes, Lordship, objection has been filed. The matter may be put for hearing. I'm sorry, Lordship.
You do not know that.
The date was not put in my office copy. I'm sorry, Lordship.
Just say one prayer made by the learned counsel.
Your Lordships, we may be served with the copy of the reply, Your Lordships.
Yes, sir,
The
Lordship.
objection
I
has
think we
been
have given to the local-
supplied to this thing.
Lordship.
This has been also
Please.
recorded therein that applicant has received it. And you have asked for
Please, Your
time to the same. So you have already received it.
Lordship.
Please check
Your
the
Lordships, then,
order sheet before you make submission.
please, Your
Is
Lordships.
the learned counsel appearing for the applicant prays for some time to go through the objection? So that is where you have received, isn't it? Your local counsel can say. Yes, you have received. You have received it.
Please, my apologies, Your Lordships. I am the proxy counsel. Actually, Mr. Pandey is leading me in
Please
this.
for hearing.
So in the miscase, you just say on prayer made by Mr. Deb, learned counsel appearing for the
Sole respondent.
Is this matter after vacation? Stop. Interim order passed audio. Shall continue till the next date. And in the main case, just say list along with the miscase number so and so.
Lordship.
Okay.
Obliged.
Obliged.
Item number 3.
Yes.
I appear for the respondent in this case, my lord. They've challenged the order passed by the Learned Trial Court, which is in my favor, my lord. I had preferred an application for, my lord, adducing additional witness in the trial court, my lord, which was allowed. They have come up on revision against that order, my lord.
Okay. So we can list it for hearing then.
Yes.
We can hear it today also, my lord. I don't know.
Listed for hearing on the next date.
It will not take much time. Issue is not
It
very
won't take, my
complicated.
lord. It won't take.
Issue is not very complicated.
Not very complicated, my lord.
Yes. What is it then? What is that? Just give us an outline of this.
My lord, here what had happened is we had filed one, the original list of witness before the trial, my lord, had started. We had filed the additional list of witness. My lord, due to some error, my lord, some of the witnesses, my lord, were not named, but the affidavit was filed. And there was certain delay, my lord. That application, my lord, that application of mine was rejected by the Learned Trial Court. My lord, the matter rested at that. My lord, after some time, my lord, one of the witnesses whom we sought to, my lord, adduce in the trial court expired. One of the witnesses in the original list expired, my lord. So the very person whose name was rejected earlier, my lord, he was a brother of the witness who was there in the original list. So we filed, since there was a change of circumstances, my lord, we filed another additional list of witnesses, my lord, to which they objected, saying that this same person's application has already been rejected earlier. But then there was, earlier, my lord, my brother who was there in the original list had not expired earlier. Now his expiry gave me another reason to approach the Honorable Trial Court
The
again.
thing is that the witness, which you have recalled now, the prayer for recalling that witness was rejected on an earlier occasion.
Yes.
Yes,
That is what
yes, it was rejected, my lord. It was rejected.
So once it is rejected,
No,
how
it
can
was
that-
rejected on a very, my lord, mistaken ground, my lord. But be that as it may, my lord, that application, but that has now given me another cause of action.
That will-
because my lord, the original
that will
person.
require elaborate hereover
Yes. I know the interim order may kindly be extended.
on prayer made by the parties. This is matter for hearing after vacation. Interim order passed earlier shall continue till the next day.
Also placed.
All right.
Not that very simple issue as you said. A very complicated issue.
All right.
Item number 4.
May I please, Your Lordship?
Yes.
So this is an application under 482, that is section 528 of BNSS, quashing the FIR and charge sheet.
What is the offence involved?
Motor accident matter.
Okay.
The person expired, but the legal heirs of the deceased, my lord, they have settled it amicably. And I've annexed the affidavit.
You're appealing for the?
I'm for the legal heirs of the deceased, Your Lordship. And Your Lordship, the respondents here has no objection if the instant case is quashed, Your Lordship.
What about the state?
As far as the state is concerned, my lord, whether because they ultimately it is the victim, my lord. Of course,
So the law has no application here. Is it not the duty of the state to see what the thing?
Lord,
You have the instruction.
of course, I am awaiting instructions. My lord.
See, these are, Mr. Bhattacharya, we understand that even there are similar matters decided by this court also. But then if you see, there are decisions by other high courts, which is totally different. Now, as the law says that a subsequent bench is basically bound by the decision of the coordinate bench. So this court also will be bound by that. But then you must have a clear instruction so that I can record it, that you have objection or you have no objection. If you say no objection, it has to be recorded.
So,
This
I'm
matter
awaiting
is,
instructions, my lord.
it is otherwise ready for hearing. This is item number,
For
This
Your
is
Lordship.
item four, my lord.
but then it will go for hearing. In the meanwhile, you just obtain the instruction.
Oh,
Okay, just say prayer made by the parties. This is a matter for hearing after vacation. Stop. In the meanwhile, the Law and State Council shall have complete instruction in the matter. Disturb. Obliged.
Obliged.
Yes.
Hearing item number 5.
Yes.
Lordship, Your Lordship, I prefer some accommodation in this matter, Your Lordship.
That is that.
yes.
Yes.
My lord, of course, I have found another judgment.
No, what about their prayer?
My lord, my request would be if it is taken up next week, my lord.
It will go after vacation. There will be no time for the court to pass. There are already matters in hand where judgment is required to be passed. So, hearing a matter now and keeping it for passing judgment after 1.5 months, that will make the court forget everything. No purpose will be served. If you do not have objection to their prayer, we'll adjourn it after vacation or we'll finish it now. It's up to you.
My lord, since my friend is asking,
On prayer made on behalf of Dr. Mojigal on FDSGA. Not objected to the Law and Council of the petitioner. List after vacation. Yes.
obliged, my lord.
Item number 12.
May it please, lordship.
Lordship, in this case, they are supposed to file objections in my
Substitution.
substitution petition.
Lordship, my objections are ready. I'm just awaiting signatures. There's been, because the petitioner is from out of station, it appears he is involved in some other criminal cases. So, which is why he's not in a position to come and sign it. I was only praying for some time on that.
Lordship,
count,
Lordship, the petitioner has also approached, because Lordship, in this case, his bail was cancelled. Lordship, and the petitioner has approached Supreme Court. Lordship, the Supreme Court wide order
In this very case.
in this very case, and Supreme Court has ordered him to come and report to the IO. And the matter got listed on 28 November. So 28 November was Friday, Lordship. Till now the order sheet is not uploaded, but to the information is that he has never reported also before the IO. In this very case only, Lordship. He was directed to appear before IO on 14/11, Lordship. He has never reported also, Lordship. More so, Lordship, he has also filed a civil writ petition before Justice. Thank you. Lordship, he is availing all his legal right in not
See, this
filing.
is order by which petitioner was directed to appear on 14/11.
14/11, Lordship.
Thereafter, matter was supposed to be listed on 28/11.
28/11
What
matter
happened
was
on
listed.
28/11?
Matter was listed, Lordship.
Then
But
what
the
happened?
order sheet is not uploaded because it was a
No, then you do not have any instruction as to what happened
Lordship.
to that part of the thing where the accused does not comply to the order of the court.
In the meantime, they have filed a cancellation before this.
Anyway,
order
you see,
court.
you see, there is a violation of the order of the apex court that will be brought in there.
Lordship.
Now, what is the matter involved here? What is the offence involved
Here
here?
we are seeking quashing of the 420, 468, 471 FIR, Lordship.
And then,
And how this matter has come, in the meantime, Lordship, we had also sought for anticipatory bail.
no, that is all right. Why you have filed an impleading?
Because the complainant expired, Lordship, and the Lordship, after due hearing, Lordship has allowed us, being the daughter, to file a substitution petition, to which they are objecting, Lordship. But Lordship, if since the complainant, since the accused person is
Any
not
interim order
filed,
passed by this court?
no, Lordship.
Then it's okay. Then let them file. So long there is no interim order, investigation will not be.
But Lordship, it is getting pending, Lordship. This it is getting lengthy, Lordship. Till after vacation, let it get listed for hearing, because
It's all
if
right.
their
It's
show
all
cause
right.
is not filed.
Just let them file a show cause. You see, like you have to. This is criminal miscase 80.
Lordship,
80,
yes.
Yes. Let them file a show cause and then we'll see that. See to it. Because without disposing of the implement application, we cannot go to the main case.
Lordship,
And as you say that there is no interim order,
Lordship.
well, then it's okay. Then may not be, you see, like a bad situation for you as of now. You see, like.
There is no impediment
then-
for the investigation as far as that is concerned. In fact, they are investigating also, which is why these kind of
So-
orders are.
This matter pending before the apex court is against the grant of bail.
Bail.
by you.
Against the ground, anticipatory bail, Lordship. Because anticipatory bail is
Anticipatory bill was
cancelled.
granted, then cancelled.
Cancelled because of his non-compliance
Against
of
the
the.
cancellation, Supreme Court, he had approached Supreme Court. Supreme Court granted again with that direction to appear, and now there is a.
He is not complying with that also, Lordship.
Just on prayer made by
By the-
Mr. Learned Counsel appearing for the in the miscase,
Lordship.
Learned Counsel for the respondent.
A respondent 2 in the miscase.
You file it to just give
Lordship,
it
please.
3 weeks time and you do it.
Lordship.
This thing. Further 3 weeks time is granted for filing objection. Stop. And the main case list along with the miscase number.
80.
Well, this also in the main case is list this matter of revocation along with miscase number 80
Of 25.
criminal miscase number 80 of 2025. Please do it, then we'll just dispose
Lordship,
it.
yes. In fact, my objections are ready since a long
Yes.
time. I'm just awaiting.
No, but then these are not very
I appreciate it, Lordship. I appreciate it.
lengthy things or major things which
Lordship, yes.
where you need.
In the event it's not filed, Lordship, we'll probably proceed for this.
Just remember his submission.
Lordship, yes.
Otherwise, let it come on record, Lordship. That he has also stated.
Obliged, obliged.
13.
Obliged.
Yes.
May it please. This is an application under section 482 of CRPC.
Yes.
Quash FIR. And the case registered on the basis of the FIR under section 420 and
468.
468.
Yes.
Now, what is my case, my lord? In brief, my lord, my mother had issued some checks in my favor. In fact, my lord, before my mother issued checks in my favor, before the FIR was filed, my lord, what happened, my lord? My mother wanted me to take over my estate. My mother at that point of time was 58 years old. She executed a power of attorney in my favor. Basically, what she wanted me to do was to collect rent from all the tenants. Now, that power of attorney is at page 25. Now,
These
my
are
lord,
not disputed. These are not disputed documents.
no, this cannot be disputed.
It is
my lord.
disputed, Your Lordship. Your Lordship, the power of attorney
Well,
was
I'll-
signed. Let
me
my
complete.
let my.
They will definitely dispute, my lord.
No,
What
no,
I'm saying is,
why you
Lordship-
say power of attorney cannot be disputed?
Well, I'm just trying to say you the sequence of events here, my lord, to show you how the FIR was filed. Lordship will come to the last page of my petition, which is page 26. This power of attorney is executed on the 12th day of January 2024. And this power of attorney basically says that you being my daughter, I give you the power of attorney to collect rent from all the tenants.
Yes.
Now, Lordship will come to the FIR. FIR is at page 21. Lordship will kindly see the date. FIR is dated.
Wait, just go. Page 21.
FIR is at page 21 and the date of the FIR is 24th January 2024, subsequent to the execution of the power of attorney. Now, if I may read the FIR once, my lord.
FIR is filed by?
Filed by my sister. My own sister, my own biological sister.
And this power of attorney is executed by your
given by my mother to me. So, well, I'll read the FIR. The type copy of the FIR, my lord, will find at page 18. Type copy is at page 18. May I read, my lords?
Page 18.
Page 18 is the type copy.
Please.
To the officer in charge, Limekura Police Station, dated 24th January 2024. FIR. Sir, I have the honor to inform you that the hard-earned money of my mother, Srimati such and such, maintained in SBI bank account number such and such, Yodo branch, was fraudulently withdrawn from time to time. The opposite money in the bank account of my mother is meant for a medical treatment and welfare of her children. Recently, when I updated the passbook of my mother, being SB account number so-and-so, Yodo branch, found that the substantial amount of money has already been withdrawn by my sister, Miss Deirdre Shilla, and transferred to her account, and from her account it has gone to the account of some persons with whom our family is having no relation. It may be submitted that my mother is old and suffering from schizophrenia, which is a mental disorder, and my sister is still a student of first semester BSc in St. Edmund's College, took advantage of the sickness of my mother, and on being influenced by some outsider had withdrawn the money.
You are the elder sister. You are the eldest sister.
I am the elder sister. Money from the above bank account of my mother. Even I am also a student of 10th semester of BSc in Anthony's College. It may be stated that either the signature of my mother was forged on the check, or she was misled by my sister to obtain her signature for the purpose of withdrawing the money from the bank account dishonestly and fraudulently without informing either me or my brother or any of our relatives. That my mother was a lecturer of Synod College, Jiao, who retired in the year 2022. Thereafter, the salary and other benefits were credited to the said account of my mother from time to time. On earlier occasion also, my sister had done the same act of withdrawing the money from my mother's bank account and transferred it to the account of her so-called boyfriends. She was reprimanded by again. She had committed the act of fraud and collusion with connivance with the person, namely Sri Melvin Rani, working at HDFC Bank, Limekura branch. Recently, when I updated the passbook, the following new transactions wherein the money was shown to have been withdrawn by the following checks as under.
Whether Melvin Rani is an accused?
My lord, he is also an accused, my lord. Now, my lord, here, look at the dates of the checks, my lord. 23, 7, 10, 23, 7, 10, 23, 23, 27, 11, 23, 8, 12, 23, 6, 10, 23.
All after power of attorney.
All after the power of attorney. And my lord, lordship will kindly appreciate one thing.
But then
where is the offence made out, my lord?
This power of attorney,
my lords,
otherwise does not authorize you to sign checks, isn't it?
No. But checks were never signed by me. My lord, had the checks been signed by me, my lord, in today's date, my lord, even sometimes my own check, my lord, is returned back because the signature does not match.
But then see the dates. All are same.
Yes,
thing.
possible, my lord,
7,
possible.
7, 10, 7, 10,
my own mother, my lord.
18, 12, say like within 1 or 2 months.
My own mother, my lord. My own mother has given me the checks. Now, what I am trying to, my lord, impress upon this court is, where is the criminal element in this, my lord? The offence under 420 and the offence of forgery. My lord, I have not forged the check. In order to bring home an offence, or to even for the police to take cognizance of an offence, there has to be some criminal element to be found. Check is signed by the mother. Check is given to me. I go to the bank. The bank, the money comes to my account, still lying there in my account. Well, if I had the criminal intention of doing anything with the money, I would have taken out the money and spent the money. That is not the case. And 420, in what manner is 420 attracted in this case?
Mother has not come forward with any.
Mother has never been examined. Mother is never. Now they are saying mother is suffering from mental illness. Now she is 60 years old, my lord.
And she has any disablement?
Well, according to them, she is suffering from some mental illness. Of course, I also say she is suffering from.
Where is that evidence that she is suffering from?
Your Lordship, in my objection, I've attached in annexation number B, Your Lordship, page 12. She's been under treatment for the last 10 years, Your Lordship, from 2015 onwards. This is a doctor's certificate, Your Lordship.
She has been under treatment is one thing to say, and that her. That means, do you want to say that for last 10 years, she has not transacted a single transaction in the bank in her name?
She has, Your Lordship, but after her.
She is other that way. That is that disability is not there. Total disability is not there with her.
No.
If she can do something, see, this has come. If you say last 10 years.
Yes, Your Lordship.
We are in 2025. 10 years starts from 15.
2015, yes, Your Lordship.
Now this transaction is of 2023.
2023.
Now before 23.
But post retirement, Your Lordship.
Do you want to say that from 2015 she is not operating her account by herself.
She is operating her account by herself, Your Lordship, but then she is suffering from schizophrenia, Your Lordship. It comes, it goes, Your Lordship. Your Lordship, if Your Lordship permits me, Your Lordship, if you see the power of attorney given by the sister, Your Lordship, this power of attorney, Your Lordship.
Let him finish.
Yes, Your Lordship.
So, my lord, if they say that, my lord, they themselves say that the mother retired from Synod College. So she was teaching. She was totally fine.
Which year she retired?
My lord, if she probably retired in the year 23, my lord, because she was 58, 59 years old at that point of time. That would be the retirement age. That is not my contention. It is their contention that she retired from the government college. She was teaching.
When did she retire?
She retired in the year.
That becomes very vital information then.
Yes,
At the time of the power of attorney, she was 58 years old. So, well, power of attorney is in 24, so she was still teaching.
We do not
perhaps
know
at that
whether
point.
age is correctly reflected there or not. Let him say that when. No, that becomes a factor to be considered so far as your case is concerned.
Well,
then I'll have to seek instructions, Your Lordship.
When
she retired, I'll have to seek instructions, Your Lordship, because even my hands are tied, Your Lordship.
I'll finish my argument and my brother will argue. Well, what is my case? My entire case is, if they say the person is suffering from schizophrenia, it is not a complete disability. There are bouts. There are certain bouts when you tend to, my lord, you are under the influence of the mental illness. Otherwise, you are fine. Now, if they say, my lord, that mother is suffering from schizophrenia and then I have...
Is it a kind of attack which comes and
living
for some time and then it disappears?
Kind of. It has stages, my lord, then it grows, then, we become more mentally, then you have a lot of...
No, but then how long that stage lasts?
Well, that I cannot say, my lord, that of medical expertise.
See, you are asking this court to interfere
my lords.
At this stage.
Yes, my lord.
Is it not that there are many things which
No, my lord, no, my lord. Those are totally different. Who is the complainant here, my lord? The mother is not the complainant. Mother is not the complainant, my lord. The mother has to come here. In the last 2 years, has the police made any effort to examine what has happened here, my lord? What is the endeavor here? The endeavor was to file an FIR and to get the account frozen. For the last 2 years, my account is frozen. And who am I? My lord, I am a college student. A college student against whom an FIR is lying, no investigation whatsoever has been done. There has to be a closure to the investigation as well, my lord. I am not a criminal. The only fault is that my mother has given some checks in my favor. Perhaps she loves me more. It is very much possible. Where is the criminal? Where is the criminality in this particular FIR, my lord? How is this FIR even registered before the police station?
Now,
my lord, if I make an allegation against a third party,
if any
saying
argument
that
is made on the basis of maybe or may not be,
my lords,
ifs and buts,
yes,
which way this court will determine that?
Well, I will satisfy this court that no case is made on. Well, I'll place some judgments also. These are otherwise, my lord. Let us see.
Come to judgment later. So
well, I will
understand the position under 420, 468.
Yes.
We know what
yes.
are the ingredients.
Absolutely, lordship knows.
Okay, for that you do not have to give any judgment.
Yes, yes.
Judgment of this court is also there.
Absolutely, my lord.
Okay. Now, as you say, you correctly say.
My lords.
Where is the question of 468 here? There is no forgery.
There is no forgery. How can there be forgery? Okay. They don't.
And if it comes to 420,
415,
probably ingredients is not there.
It's not there at all.
Mother is not there to say.
Not at all, my lord. Nowhere in the picture.
That she was deceived to
yes.
deliver some problem.
Yes.
Isn't it?
Yes, my lord.
That way ingredients are made.
Absolutely, my lord.
Now there are another aspect.
My lords.
If we see the stand of the other side.
My lords.
That mental disorder. Now if that be the thing, definitely if she does something without understanding the consequence of that, that has to be protected.
So then, in that case, my lord, if I may, I ask myself, my lord, in that case, my lord, whatever statement she gives tomorrow before the police, even if she speaks against me, my lord, will they help the other side? Not at all. Not at all. If they say that I suffer from schizophrenia and I am totally disabled, then it will not even help their case. So where will the FIR go, my lord? So what is the stage of the investigation? That is what I want to know.
Will it mean that like you will have all the checks and you will
No, my lord.
Basically,
my lord, kindly appreciate
the entire account.
Kindly appreciate, my lord, the dates the checks were given to me, my lords. Kindly appreciate. And if a mother gives a check to an elder daughter,
what is surprising is that you need so much of money within such short time.
My lord,
you are a student.
Yes.
Not studying in foreign country.
My lords.
Isn't it?
Yes, my lord.
Reasoning here.
Yes,
but then you need say like 4 lakhs one day, next day 10 lakhs.
Kindly appreciate one thing, my lord. Kindly appreciate one thing.
It gives some suspicion.
Kindly appreciate one thing.
This case may not fall strictly under 468 and.
So will suspicion allow a criminal case to be registered and investigated against me?
Be something like that. You are taking advantage of a situation.
My lord, if that is the
By
case, my lord,
manipulating the situation.
kindly appreciate just one thing, my lords. Why is the power of attorney given to me, my lords? Why is the power of attorney given to me? The power is given to me because, my lord, my mother wants me to take care of the estate. My younger sister is not doing anything. And she wants to make sure that all the money doesn't go to her. Otherwise, perhaps it will go into wrong hands. That is another aspect of looking at the matter
The
also.
thing
My
is
lord.
that you see, you are not keeping the money with yourself. That is the main thing.
My lord, I have invested money from HDFC Bank in mutual funds and whatnot, my lord. I want the money to grow. I'm not just wasting the money. Well, money can go to any account. The only thing I argue, my lord.
It is not that you are not transferring it to somebody else.
I may transfer to anybody once the money comes to me.
Why you are talking about your right, you see?
Only,
right now.
my lord, the only
Just
thing.
say whether transferring of that money
Was there a criminal act, my lord?
would give rise to some sort of suspicion.
But is that a criminal act, my lord?
Keeping in mind.
Is that a criminal act?
Factual. See,
Well, it's
we do not know whether the mother is suffering from mental illness or not. This court will not be in a position to determine.
the investigating officer would be in a position. my lords.
Wait. Until and unless there is a conclusion. Now, do you want to say that in case of parents, those who have some mental ailment, and that if any of the kids they take advantage of that mental ailment, the other will not have a right to rescue or protect the parents from that thing?
On what basis, my lord, on the basis of this FIR, do we come to a conclusion that I am taking advantage of my mother, my lord? There is nothing of that sort.
See, you say you are a student.
Yes, my lord, I am a student.
Wait, why you get impatient?
I'm just,
Court may put you more question than you expect.
in fact, well, I appreciate being questioned like
Sometimes
this.
you may feel that the court is basically opposing.
No,
you.
man.
It is not that. Okay.
I really appreciate, my lord, this kind of
Be
an exchange
mindful of the
between
fact that just because court is asking you a question,
Well, it's-
the court is expressing that opinion.
No,
It's not that. Until and unless we finish hearing, there is no question of coming to it.
Absolutely.
Now, the thing is that
Well, it's-
if you are a student, if you are studying in St. Anthony's College, the requirement of so much money by you within a span of 2 months, very unusual. And that gives rise to a suspicion which may go to favor to others. You may stand up and say that yes, does it constitute a act under 468, 420? It's not.
I'll reply, my lord.
But then it may show a part of, you see, like a kind of guilty intention on your part to take advantage of the situation. And you see, by taking advantage of the ailment of your mother, you siphon off with all the money.
My lord used the word siphon. So may I just reply? Can I reply, my lords?
Well, see, you take out. Okay, yes.
Well, may I reply? Lordship, kindly see the dates on which the check is transferred in my account. Now, if I had a slight guilty intention, my lord, the money would not be lying in my account.
Can you go to all those?
I'm sorry, my lord.
Can we go to all those details in
No. Exactly. That is what I'm saying, my lord. The only thing we'll see is whether an offence under 420 or 460 is made out or not.
Only on the basis of that.
Only on the basis of that, nothing else.
Keeping in mind Bhajanlal's
Bhajanlal's parameters very clear. Well, whether the FIR discloses any offence, it does not. This is a purely civil dispute. Even if we say there is a dispute between the parties, if I have taken more money from my mother, which you are entitled to, go file a recovery suit. Show that you are entitled to. You cannot file an FIR on the basis of the FIR, make me a criminal when I am a college student.
When this mother, she retired from service?
My lord, according to me, my lord, I don't have the information right now. That is the plea. That is what they have mentioned in the
Who is the
in the
applicant for the
FIR.
state? Yes. What is the... Come this side. We cannot see you. Just tell us, what is the stage of investigation? What is the stage of...
sought for anything from the authorities, my lord, without the leave of this court, my lord.
It's almost 1 year.
No.
My lord, I have not sought
What
any
leave you need
instruction.
from the court for?
My lord, till that point which has not been...
No, that is... see, like...
Police, they are doing their job. Police, they are doing their job.
You do not have to ask for any authority from the court to have instruction with regard to the status of the case.
My lord, in that
should be
case...
placed by you. That is automatic. Otherwise, how you stand up, how you defend this case, just tell us.
My lord, I was...
Are you standing up to defend the case or to support the case? Just tell us.
No, my lord, I am to defend the case. My
Then they tell us.
so,
what
my
is
lord,
your
my lord will have to grant me a week's time, and
you could have said it at the very beginning.
No,
Tell us at
without
least,
giving
see,
him...
This court basically would like to know the date of retirement of the...
Date of retirement.
You just cannot come up with the plea that she has mental impairment. If a person is in government service, retained in government servant, we cannot presume that she had some sort of mental disorder. Just for the purpose of, like stopping her to transfer her money to...
Date of retirement and what? I'll get a status report, my lord.
Is it not important, date of retirement?
My lord,
If
that
it's
will,
prima facie,
that
we
will
have to
show
give
that, my lords, that will. My lord, otherwise also, my lord, I say.
Can't it be your argument that if a person can be retained in the
Yes,
government
yes,
servant
yes.
for such a long time, how that contention
My
is
lord,
raised that she is mentally ill for
My
10
argument
years?
is very clear. My argument is, my lord, even if she suffers from schizophrenia, she's not totally disabled. If they take that plea, then my lord.
We do not know. This court has no idea about that
Yes,
statement
yes.
and how much bearing it has on a person so far as her own normal thinking is concerned.
If a person is suffering from that level of schizophrenia, there is no question of signing checks also, my lord. To that effect, that, my lord, the
How do we
signature will
know
also
it?
match.
That is your submission. Just give us something medical. This thing.
So, my lord, we can have it, my lord.
You
My lord,
have
there
any
is some.
decision to say that thing that that schizophrenia has this limit or that limit, something like that.
But that judgment I don't have with me. Well, I am only concerned with, my lord, 420 and 468.
That is the only issue to be decided. 480 to 468 is okay. It may not be there.
So, my lord,
But
this
then
instruction.
if FIR
My lords.
takes out allegation, which can be charged under any other section of law,
My lords.
then may not be a fit case for question.
Yes, if anything else, if it shows any criminality at all.
That is where you apparently what you say, FIR is very much clear. It doesn't spell out any commission of any
No offence at all.
and especially this the complainant also has no right. If it is mother's money and
Yes.
mother has not come out, is until and unless it is shown that mother is suffering, she is bedridden or she is incapable of doing any normal thing, then we can understand. Otherwise, a person is retained in government servant and at the same time if you come with a plea that she has mental illness, this court will not accept.
Exactly. It is their own plea that she retired as a government servant. My lord, can we have this
I'm
on?
back with a medical certificate given by the doctor that she's...
That we will not evaluate. What medical certificate says? Show us what medical.
Does it say that she is disabled to the
And
effect that
state
she
is a
can't even
silent
sign?
spectator. Huh? State is not doing anything, Mr. Shangupta. State is a silent spectator. So state is not doing anything. And would
My
not
lord,
like to do
I'll
anything.
get the instruction and I'll be in a better position to
Please
assist.
get
my lord.
get the latest status of these things.
Absolutely, my lord.
Well, there is some urgency in this matter, my lord. The last 2 years, almost 2 years, my lord. January the FIR will be 2 years.
See, if it is
Money
2
has
years,
been-
then we can.
money has been
we
frozen.
have to wait for some more time because we do not have the vital information with us.
So we can have it on Monday.
Otherwise,
my lord.
you also
I
tell
can
us.
supply the information, my lord, as far as retirement is concerned. My
Okay,
lord,
you
wait
can
tomorrow
supply that,
itself.
But then it is better if it comes from their side.
My lord, may I...
What your medical certificate says?
Your Lordship, if you can come to page 12 of my objection.
And can you take into consideration that medical certificate at this stage?
She's been under this doctor's treatment for the last 15 years, Lordship.
Yes, what
The
they
doctor
say?
states that the nature of her illness is such that she needs to be under medication indefinitely, Your Lordship.
That is okay.
Medication
She's fine
doesn't-
with medication.
She was teaching in a
It
college.
this doesn't speak about any mental this thing. Then it's good enough. If you say that is enough,
But Your
that
Lordship,
is
if
enough.
she's
That is
not
good
under
enough.
medication, then this schizophrenia set occurs, Your Lordship.
My lord, may I just say one
If
thing,
she
my lord?
forgets to take her medicines, Your Lordship, then this schizophrenia
Yes,
occurs.
you come up with we'll have it after a week. You come up with your
After a week.
You can have it on Monday, my lord.
No, Monday will be too short, my lord.
We'll have it after a week. We'll just see
After a
what-
week, my lord. My lord, would you like to see the case diary, my lord? Or a status
If
report?
you think that is this thing, you can have it with you. If required, we can this thing. But
I
then
can say nothing
we
has
just-
been done, my lord. As far as
If
investigation
nothing
is
has
concerned,
been done,
nothing has been
my lord,
we would like to see what is this.
what is the progress, my lord?
Of these things. Yes.
Obliged.
Just as prayed for by Mr. Shangupta, learned edition will appear from states. Release this matter after 1 week. The learned states shall have
The latest status report.
shall have instruction with regard to the latest status of investigation in
Limukra Police Station case number 27-2 of 2024. Under section 420 and 468 IPC.
You got it? Have you got the police case number and all? Check.
27-2?
Yes.
27-2 of
Where it is
2024.
reflected?
In the cost title.
In the page 1.
Limekura Police Station case number 27 under bracket 2 of 2024 under
First
section
page of the
424.
cost title. Case number 27 within bracket 2 2024 under section 424. List accordingly. Yes. Please see it. You see, unnecessary. You should not. This kind of things you do not know. See, and then who else are there in the family? Apart from these two, you do not have any
His
other.
one brother who's married. So I'm the eldest.
He's
living with his wife.
He's elder to you.
But he's elder to me, but he's living with his wife, so I am the eldest. That is why, my lord, the entire
And your
responsibility is upon me.
father is not there.
Father is not there. Father is not there.
It's a very peculiar situation.
Very unfortunate, actually, my lord.
Given this
to
power
look
of
at it.
attorney, Your Lordship, like none of the family members are aware of it, Your Lordship.
Go to civil court, file a case.
That's for the civil court to decide. Where is the criminal intent, my lord? Unnecessarily have been
Shortcut.
dragged into a criminal.
This certificate will not suffice things for you. Yes, we'll have it.
Much obliged.
Item number 14.
Yes.
Wait, please, Lordship. So they are connected.
This will take time.
Lordship, it was heard on the last occasion at certain. This was the case where after a plot was sold, money was paid, no registered deed was drawn up, only on the Kachcha sale deed. And after about 1 year, while being in
Any
possession of that,
urgency, if you have urgency, then we'll come back and the second time we'll have it these things. Now, it is already alleged.
Lordship, I have it tomorrow. Lordship, I have it tomorrow if possible.
Tomorrow is difficult. You see, like this division bench, single bench, and all. It's very.
You can have it after the vacations, will it?
So if that is what, if you say that is.
My only difficulty on the last occasion also I read to the trial is otherwise, Lordship.
What is the stage of the trial?
Towards the
Charges have been framed. May I just give your lordship a small nutshell. There's one just objection that I need to bring, and I was just telling my friend, as on date when they filed this application, only a charge sheet had been filed. The court had not taken cognizance of the matter. But he's filed for setting aside the charge sheet. In the meantime, the development is the court has accepted the charge sheet and formal charges have been framed. Now, those need to be assailed together with this. There's a recent judgment of the Honorable Supreme Court on this point as well. That's the only issue.
The discharge has to be challenged.
Yes, because it's a judicial order, my lords.
Discharge.
There could be an alteration of charges. There could be anything.
See, probably there is a decision by the apex court recently.
Yes, my lord.
It has come that even in cases where quashing is sought, and even if court finds that prima facie there's force in the thing,
Yes.
but in the meantime, if the matter is charge sheeted, then the proper thing is to file a discharge application before the trial court and get the discharge there.
That is one way, and even under 226 or 482, that has to be assailed with requisite pleadings. That's the judgment here. Very recent judgment.
Please give him that.
Yes, I'll serve him a copy. He may examine it.
Sealed the entire proceeding. We had sought discharge, that was denied. So I can bring that on record.
No, you have not brought that order.
I have not brought that. Lordship, I will just file an affidavit.
So this order is from September 2025.
Just to assess this court, at the time when the petitioner filed, it is in their pleading that they have filed this petition pending that order of discharge.
Okay.
So the
Now-
order
now-
was passed later on.
Okay, it's okay. Let him bring in the
That order
discharge.
is not on record before.
Anyway, then we'll do it.
File that order.
Okay. Now, if you file a discharge application there,
It has been rejected.
during pendency, how could you invoke this jurisdiction
It was not
simultaneously?
during pendency. My discharge was already
That,
pending.
but then Mr. Jirwa says that there is a statement by you.
No. In my criminal petition, I have made a affirmation that my discharge petition is pending before the trial court.
That means you invoke jurisdiction of two courts at a time
Lordship, yes.
for the same relief.
Not for the same relief, Lordship. Because
Relief
discharge-
ultimately same. If your discharge is allowed,
Lordship, yes.
then what is the purpose of this?
No, it was entertained. I was not discharged, which is why Lordship I entertained.
See, this is not very good practice, not a very healthy practice. That could have resulted in passing of two different orders by this court. One is rejection of this thing, quashing, at the same time allowing of your discharge, or maybe vice versa.
Lordship, that I appreciate.
So that, please be mindful of that.
Lordship, because
You may not have done it intentionally, but then be careful about that.
Lordship, yes, because what had happened is at
This
the time
court
of
is very serious about those kind of
Lordship,
things.
at the
Mr.
time
Deb.
of motion, Lordship, that was indicated, and we had fairly said that in the event,
You have indicated it is pending. It is pending. That is what Mr. Jirwa has.
Lordship, yes, and it
Anyway,
what
just Mr.
subsequently it was not. I
Okay,
was
Mr.
not
Deb,
discharged.
Learned
so
Counsel.
I'll just file it.
Yes,
by way of
Learned
an
Counsel
affidavit.
submits
Have it next year only.
that the petitioner. Have you said that this has been charged? Anyway,
Lordship, yes. I have seen the entire proceeding, the entire GR case, Lordship.
Paragraph 2 of the petition. That the order of discharge is pending.
This should have been pointed out at the time of the motion of the matter. Why it was not done?
Lordship, it was, and what had fallen from this honourable court is that let us await the outcome. And thereafter, I was not
Has it
discharged.
been recorded anywhere? Do
It
you not
was
know? Normally,
It was not. It was pointed out. In fact, which is why I had averred it. So it was not a question.
no, at least if not, the other side should have pointed out that one. Of course, private respondent was not there.
No, I had also pointed out, Lordship, that this is pending. What had fallen at that point, of course, it was not recorded, Lordship.
Just say it is submitted by Mr. Dev, Learned Counsel with the petitioners, that the discharge application preferred by him in the connected GR case number 37 of 2024 has been rejected by the trial court. He submits that the copy of the order of, what is the date of rejection, you know?
Lordship, 11/7/25.
Rejected by order dated so and so, just say on the
11/7/25.
in the previous line. Okay, you just read the date. Date is
11 July.
11/7/2025.
He submits that the petitioner would like to bring on record the said order dated so and so into record by filing an additional affidavit.
And my lord, may I just also add, two orders need to be brought on record. The formal order taking cognizance, because that has to be challenged now. That's the decision of the Honorable Supreme Court. The formal order, that happened on the 21st of July.
Anyway, I do not know whether he will agree with that proposition.
No, I have the order with me.
It's okay.
Anyway, I understand. I understand what your lordship is saying.
He may have something.
He may
else.
have a different.
So that
Correct.
liberty will give him. If he thinks, but then of course,
Anyway,
it's
I'll
not
supply the
there to
copy of the
address,
judgment.
but then for that is for abundant precaution, it is better to do it.
I'll
Isn't
do
it?
that, Lordship.
Anyway, what was the last time? And he prays for?
Just noted down.
And prays for.
I have just one and
Not of some time.
Yeah.
Stop. Paragraph. Pair allowed. Stop. The petitioner shall also with liberty to bring on record any other relevant order which may be necessary for consideration by this court at the time of the final adjudication of the matter. List of application.
Obliged, my lord. Similar order for the next items.
Only the GR case number will change. It's the same order.
What is the GR case number there?
In the other is GR 27.
27. And
27 and 37.
27 and 37.
this present one which you have passed order is in
This is in GR 37.
GR 37.
Lordship.
So other one will be 27.
27 is the same order of 11/7/25.
Similar order.
Please check that before this thing order. Yes. There will be other matters. Yes. Who are the-
70.
Obliged, my lord.
Yes.
This is petition of that compromise between the parties. And
What is the offence involved?
307, 354, and 326.
And what is the stand of the state here?
My lord, the offence is very serious in nature, and moreover, my lord, they have come at a very belated stage because, if I'm not wrong, as has been
26 they have recorded the
informed,
313.
the matter is at the final stage of.
We had filed this case also
Trial.
before this court to stay the proceeding. The court is not allowed to that.
Okay.
So
It is.
What is the stage of the proceeding now, you said?
313, no?
313 is the 2611 is
For hearing.
Now it's for proceed for hearing.
Final hearing. At a very belated stage, they have approached this court.
That is okay. But then, there are decisions.
Yes.
By this court also.
And if you also look
That
at
is basically stemmed from a decision by coordinative bench. And state had never at no point of time challenged it. Now that becomes a problem. Yes.
Since the party, may I proceed? Please.
You have to wait. We'll have to come back after lunch break.
May please order, Your Lordship. This is the petition filed by the petitioner after the parties come into conclusion of compromise, white compromise dated 21st June 2025, July 25. So the petition was filed invoking section 528 BNSS, the inherent power of the court to quash the FIR and criminal proceeding against the petitioner, the case pending before the session court at Mokurwan. So, in this case, Your Honor, I'm here before this honorable court on one ground, that is a compromise. The other is that both the party have settled the differences. This case.
Both the grounds are same, it means.
Yeah.
Compromise and settlement both are same.
Yes, yes. Compromise, settlement and compromise. So this is that because both the accused person and the complainant or the victim, they are relative, as the accused person is a husband of the relative of the victim. So they don't want that the relationship between within the family.
Accused person is the relation of?
Is the accused person, or the wife of the accused person is the cousin sister of the victim complainant.
Okay.
So
what is the FIR? What is the
FIR is I will take to page number 15.
Yes.
15 and 17 is a
typed copy.
It's yes, a translated copy. May I read, Your Lordship?
Yes, please.
With reference to the subject cited about, I, Srimati, so and so, I felt very sad that Bimlan Soshang, he used to beat me, but from my family, they had a meeting with his family to settle the differences in Remberngau village at 1 p.m. on 10th 8/2021. From Bimlan Soshang, he demanded rupees 1 lakh, otherwise he will not settle the matter with abusive language, and if he did not pay 1 lakh, he will kill me. From the meeting, he ran away. From my family, they asked me to go with my cousin brother. After we reached halfway, Shri Bimlan Soshang, who had followed from behind with the knife, would attempt to murder my cousin brother, Shri Kharidar Linkoy, and he dragged me into the forest and dragged me from my body. Therefore, with this, I request you to take action against him.
The accused wanted to
Your Honor,
cause harm to
the
Kharidar Linkoy.
Yes.
But then he did not do.
No.
Instead, stabbed the complainant.
Your Honor, in this case, it's not that he want to stab. The fact of the case is that he did not. He's not that he want to stab. That but he has a knife. Of course, because in the rural area, people who used to go to the party field, or they used to put some knife or some any like.
They used to carry something
yes,
like
betel
that.
nut or something like that. But in this case is that on this particular day, on 10 August 2021, after they found that the victim or the complainant and the accused person, they are in living relationship. So they did both the relatives of the family from the accused person and the victim, they disapproved that. Since that the wife of the accused person is a cousin sister of the victim. So they settled.
So it is not a case of a motor accident, isn't it?
No. So, if I would like to bring you to some the statement of both the victim and the accused person.
Statement
but before we came to that, I would like to take you to page number 55. After the incident, the police take the victim and the accused person to the hospital. page number 55, along with type copy 56.
Yes.
So this is the nature of the case, Your Honor. If you come to the summary in the last below bottom of the summary, she is physically fit. This is medical report. She is physically fit with no sign of any disease or illness, no injury in anywhere in the body. So this is it's not the case of that he stabbed her or anything. That is just
307 doesn't come.
No.
So the basically the complainant was not required to be hospitalized.
No. She's not admitted in the hospital.
Now you have compromised.
Yes, we have come to conclusion that we are compromised.
Yes, you are with private respondent, and your husband and wife.
We are in a live-in relationship, Your Worship.
Still you are living together.
No, Your Worship.
You were. Okay, and now, so far as the compromise is concerned, you agree.
We have already compromised, Your Worship.
So you do not have any further grievance.
No, Your Worship.
Yes, interesting one.
My lord, as far as the offence is concerned, my lord, this is under 307 and 307
Medical report
IPC.
doesn't say so.
My lord. Now, my lord, in similar such circumstances, whether this can be compounded, because in one case, my lord, matter was compounded and ultimately it went before the Honorable Supreme Court, and in similar instance, my lord, I'll just give a copy.
It was allowed by this court.
No, my lord, Madhya Pradesh, if I'm not wrong. Madhya Pradesh, I think. I'll just read, my lord, this small judgment, my lord.
Yes.
Being aggrieved and dissatisfied with the impugned judgment and order dated so-and-so passed by the High Court of Madhya Pradesh in miscellaneous criminal case number so-and-so, by which the High Court has passed the criminal proceeding pending against the present respondent herein by crime number so-and-so for the offence under section 307, 294 and section 34 of the IPC, registered at the police station so-and-so, the state of Madhya Pradesh has preferred the present appeal. The respondent number 5 herein, the original complainant one Bribal Sharma filed a complaint against respondent number 1 to 4 herein the original accused for the offence under section 307, 294, 34 IPC, that the said complaint was registered as crime number so-and-so at the police station so-and-so. It appears that the original accused filed an application for bail which came to be rejected by the learned session court, and thereafter the original accused approached the High Court by filing the miscellaneous crime number so-and-so under section 482 CRPC and requested to quash the criminal proceeding on the ground that the accused and the original complainant have settled the dispute amicably. That the original complainant submitted his affidavit.
There was more than one accused, isn't it?
Yes, my lord.
And then the order says that who approached in court? That is
State of Madhya Pradesh, once the matter was quashed by
that is
High
by Supreme Court.
Yeah.
No, but that is
before
what you are reading now.
Yes, my lord.
It appears the original accused filed an application.
Yes, my lord.
The original accused.
Original accused. My lord.
And then if you see the first line of the paragraph 2, that says, it says,
original
5
complaint.
herein, the original complaint, filed the complaint against respondent number 1 to 4.
1 to 4.
It means
Herein
there are
the-
four
accused, my lord. 1 to 4 in this case, my lord. And
then who
one of the accused, my lord, it says here, it appears that the original accused filed.
There are 4 original accused.
Probably, my lord, 4 of them they filed the appeal, my lord. It is not clear from here.
You are making submission on assumption.
Yes, my lord.
You want us to assume the situation.
My lord, it says
Because it
original
doesn't
accused
say
means.
the accused persons, isn't it?
Yes, it says original accused.
Anyway,
It appears that the original accused filed an application for bail which came to be rejected by the learned
so
session court.
there was one application.
Yeah, my lord, probably one. Yes. And thereafter, the original accused approached the High Court by filing the miscellaneous criminal case number so-and-so under section 482 CRPC and requested to quash the criminal proceeding on the ground that the accused and the original complainant have settled the dispute amicably. That the original complainant submitted his affidavit stating that he has amicably settled the subject matter of the crime with the original accused and that he has no objections for dropping the criminal proceeding. That by the impugned judgment and order, the High Court, in exercise of power under Section 482 CRPC, has quashed the criminal proceeding against the original accused, which were for the offence under Section 307-294, read with 34 IPC, solely on the ground of the original complainant and the accused have settled the dispute, and the original complainant does not want to prosecute the accused, and therefore there is no change of a recording conviction against the accused person, or no chance. At this stage, it is required to be noted that the said applications was opposed by the state, observing that the offence alleged against the accused are non-compoundable offences, and therefore even if there is any settlement between the complainant and the accused, the complaint cannot be quashed. However, despite the above, the High Court quashed the criminal proceeding against the original accused on the ground that there is a settlement between the complainant and the original accused, and the original complainant does not want to prosecute the accused further. Feeling aggrieved and dissatisfied with the impugned judgment and order passed by the High Court quashing the criminal proceeding against the accused for the offence under Section 307-294, 34 IPC, the State of Madhya Pradesh has preferred the present appeal. We have heard so and so, my lord, and thereafter 3.1. It is required to be noted that the original accused was facing criminal proceeding under Section 307-294, read with Section 34 IPC. It is not in dispute that as per Section 20 of CRPC, offences under 307-294, read with 34 IPC are non-compoundable. It is also required to be noted that the allegations in the complaint for the offence under Section 307-294, 34 IPC are as much very serious. It is alleged that the accused fired twice on the complainant by a country-made pistol. From the material on record, it appears that one of the accused person was reported to be a hardcore criminal having antecedent. Be that it may, the fact remains that the accused was facing criminal proceedings for the offence under Section 307-294, 34 IPC, that the offence under these sections are non-compoundable offences, and looking to the serious allegations against the accused, we are of the opinion that the High Court has committed a grave error in quashing the criminal proceeding for the offence under Section so and so 307-294, 34 IPC solely on the ground that the original complainant and the accused have settled the dispute. So they have quoted one judgment, and ultimately the last paragraph, my lord. In view of the above and for reasons stated above, the present appeal is allowed. The impugned judgment and order passed by the High Court in miscellaneous criminal case number so and so is hereby quashed and set aside. Consequently, criminal proceeding being so and so under Section 307-294, 34 IPC registered at police station so and so be proceeded further in accordance with law and on its own merit. Now, only here is only the difference is, my lord, the manner of commission of the offence. Now, there in that case, my lord, those were hardcore criminals where they have used a country-made pistol and they have fired 4 shots. Facts, as far as present case is concerned, slightly different.
That's why in the case of
yes, not slightly different.
Right.
There is a major difference.
Lakshmi
Yeah.
Narayan,
Yes, madam.
it's clearly said that.
It's okay. It's okay. Just we'll come to you. Just let him finish.
So,
Just-
and my lord,
see, this what the apex court has said here is non-compoundable, non-compoundable. See, quashing power of quashing exercise only in non-compoundable cases.
that is
If it is compoundable cases, then there is no question of
no point
exercise.
of yes, it can be settled down.
So we can.
Yes.
See, that is, see, like, if you see that right from the Gyansing's case, when the proposition has been propounded by the apex court, this is only to, like, facilitate the parties, those who compromise the matter, involving offence which basically has no bearing with the public element.
My lord.
Just to, you see, like, facilitate to the parties to compromise the matter and for showing of the matter. So that no purpose basically is. Now that is what. So in a compoundable offence, 482 or 528 as you say is not exercise.
Yes.
So that part has
Yes.
nothing to do with compoundable or non-compoundable.
Yes, my lord. So now here, my lord, as far as 307 is concerned, I have gone through the medical report also. My lord, if my lord will see the medical report.
That has which Mr. Carlindo has pointed out right now.
Yes.
56, page 56.
It. Page number? 56, my lord, page number. This is the medical report of the victim, my lord. It does not show in any injury, my lord, as far as medical report is concerned. So, be that it may, my lord. As far as 307 is concerned, my lord, at the trial, my lord, what will happen, we do not know. However, as far as other sections are concerned, my lord, 354, my lord, assault or criminal force to women with intent to outrage her modesty. Those other sections, my lord, there may be every possibility, my lord, the accused have a chance of conviction, my lord. So my humble prayer is at this stage, because they have approached this court very belated stage, and my lord, at the final stages of hearing, the matter is 313 is already over. So
But then this stage has any hearing, so far as the compromise is concerned. Will it be an embargo for the court to consider this application?
there is no embargo, my lord. My lord can always use its
Yes, what you will say about 307? You have any decision of apex court in this regard?
Yes, we have the apex court. What is Lakshmi Naran, State of Madhya Pradesh?
What is Lakshmi Narayan is 2019 decision.
2019, yes, Your Worship.
Mr. Sinkan, you know about that Lakshmi Narayan case.
Can I have a copy? Just give me. Or you want to read?
Yes. That is also state of Madhya Pradesh.
Yes, yes, State of Madhya Pradesh.
And what is the relevant part?
Relevant part is paragraph number 11. Paragraph 11, may I read, Your Lordship?
Yes, this is Narinder Singh.
Yes.
It refers to Narinder Singh, it's okay. But then this, in this, yes.
Also 15.4 paragraph.
Yes, what does it say? Yes. Yes, offence under 307. Please read out that.
To read out.
Paragraph paragraph 11. At the outset, it is required to be noted that
15.4, 15.4, read 15.4.
15.4, yes. 15.4 is offences under section 307 IPC and the Arms Act, etc., will fall in the category of heinous and serious offences, and therefore are to be treated as a crime against society and not against the individual alone, and therefore the criminal proceeding for the offence under section 307 and or the Arms Act, etc., which have a serious impact on the society cannot be quashed in exercise of power section 482 of the code, on the ground that the parties have resolved their entire dispute among themselves. However, the High Court will not rest its decision merely because there is mention of section 307 IPC is there for the sake of it, or the prosecution has collected sufficient evidence, which is proof, if proof, will lead to framing the charge under section 307 IPC. For this purpose, it will be open to the High Court to go by the nature of the injury sustained, whether such injury is inflicted on the vital delegates part of the body, nature of the weapon, yes, etc. However, such an exercise by the High Court will be permissible only after the evidence is collected, after investigation and the charge sheet is filed, charge is framed, and or during the trial. Such exercise is not permissible when the matter is still under investigation. Therefore, the ultimate conclusion.
What is the stage of the thing now?
Now it's the stage is it's 313. It's completed.
Now, what is the evidence recorded?
The evidence.
So far as the injury is concerned?
The complainant also in the.
What is the evidence?
They have not brought it.
No, we did not.
That will be required if you want to take benefit of this decision, isn't it?
Yes.
See, this is, if you read again from this thing, from however,
Yeah.
that is, okay, it's a High Court would not rest its decision merely because there is a mention of 307, as your case, as you say now. Okay. Or the charge is framed under the provision. It would be open to the High Court to examine whether the incorruption section is there for the sake of its prosecution has collected sufficient evidence, which if proved would lead to so and so. For this purpose, it would be open for the High Court to go by the nature of injury sustained, whether such injury is inflicted on the vital delicate part of the body, nature of weapons used, etc. However, such an exercise of the High Court would be permissible only after the evidence is collected, after the investigation and the charge sheet is filed. So now your case is advanced mode.
Yes.
Now just give us to take this 161 statement and the evidence, so far as the injury is concerned.
161 is there.
See, in view of the objection raised by the state, we have to undertake that exercise now.
In that case, I will take instruction, then I will file it.
Instruction means like you have to bring it on record.
Yes, on record, yes. We'll file the affidavit. But at the same time also...
No, you should have done it then, by now. Now it may be again too late for you. By the time you bring it on record, the trial court may pass some, but 313 has been done.
313 has been done.
It's being done, or it's been done?
26 November.
No problem. We cannot, without looking at that, we cannot. You have pointed out to page 56, okay.
Yes.
But then whether that has been exhibited or not, how do we know? And what is the evidence adduced by the doctor who issued that certificate? That also will be vital now.
You know, if you look at the nature of the case also from very beginning, from the statement 161, 164.
Where is that 161 statement?
Yes,
And
I will take you to your receipt if you.
So what is the injury is concerned?
27.
The victim is 27, page 27. Actually, both the parties, they are, the victim and the accused person, they are not in that situation. But because there's disapproved by the family members, who they have been.
We can understand that. What you are saying, we are understanding that. But then the only thing is that if law prescribes something to be done in a certain way, we have to follow that. That is a problem.
Yes. So may I read your lordship this evidence?
Yes, is what that. Read that. What is that? Page 27.
27 is this is a statement recorded under 616 CRPC by the complainant. The above particulars are true. My husband.
Which particulars are true?
If from the your lordship.
No, it starts with above particulars are true.
Yes.
That means above means what?
Above mean that is that means she is the person and the.
Okay, the name and the details.
Yes, and the details. My husband, late Twi Philos Kharbani, has expired on 26/8/2020, and his first death anniversary will be this year. I had 5 children from my late husband. After his death, I decided to stay with Shri Bimlan. We had living together as husband and wife for a while, but my relative did not approve of our relationship since he is married to one of my relatives. Shri Bimlan Soshang used to physically abuse me, and I used to receive bruises. The family members did not also like that fact that he used to beat me. So a clan meeting was held at my house for our separation. Shri Bimlan Soshang demanded 2 lakhs from my relative for him to decided not to stay calm, leave his wife and children and be with me. So after the clan meeting, my relatives decided that I should go and stay with my relative at Langleo village. Therefore, at around 4 p.m., my cousin brother, Shri Klandar Linkhoi, and my nephew, so and so, were on our way to Langleo, and when we reached Kantai Kantayai ground, Sri Bimlan, who had followed
No,
us.
but then we talk. Take us to the injury part. Where do you determine injuries?
No. That in the last sentence, we had this is 3 line before. The
We
last
have seen. I have seen the last line. You see,
Yes, sir.
but then we want to know the nature of injury. It says about 2 cuts.
Yes.
On my left buttock, isn't
yes,
it?
yes, sir.
Now, what is the nature and gravity of those injuries?
There's no such, Your Honor. If you
No, but then once this evidence is collected there, that you have to see that this Lakshmi Narayan's case is made it clear. You see, for the purpose it would be open to the High Court to go by the nature of injury sustained.
Yes.
Whether such injury is inflicted on the vital delicate part of the body, nature of weapon, etc. How such an exercise will be permissible only after the evidence is collected by the investigation and the charge sheet is filed. The trial court. Now the thing is that here in your case, matter has progressed further, isn't it?
Yes.
Now the court has taken recorded evidence.
That's true.
Now the value of 161, it loses its importance so far as the purpose of this case is concerned. Then the only thing remains for this court is to see the evidence. What is the deposition of that complainant in that court, and then the medical deposition of the medical witness?
We did not annex because since Your Honor, we rely on the compromise deed.
No, but then that decision given by Mr. Sinkan, you have seen that.
Yes, that
it is just because of compromise cannot. Once 307 is involved, so it has to be considered as a serious crime. And in such a case, mere like compromise would not result in quashing of the thing. Now you have to counter it by looking at those injury reports.
In that case, Your Honor, allow me that I will bring on the additional.
You can bring it,
Yeah.
but
at
then
the same time, Your Honor, if you allow that the miss case we are filed for still at this stage, it's the last stage, but
you see, you are yourself you are relying on decision. It was incumbent upon you to do it before. You should have done it before.
we had another judgment. This career Linkoy passed by the honorable court also, the state of Meghalaya. That is
307.
Seems it's 307.
Is there any statement of medical officer under 161?
161. Your Lordship, page number 33.
33.
33. Yes. He did not say anything. That he just said that he collected the blood. Only that. Picture.
No, that is about Caesar, nothing else.
Yes.
No, but then what about the opinion with regard to the injuries?
No,
there is no other medical report apart from that page 56.
No other.
What is the decision of this court? Justice. Oh, that is by coordinate bench.
Yes.
And what is the relevant part?
Its relevant part is 21, 23.
And 23.
Yes, 21, 22, 23. May I read, Your Lordship?
That is on this thing. This is basically proposition laid down in Narendra Singh case. What is the finding of the court?
The finding of the court is that uh, at pitch number 2 at paragraph number 24. May I read, Your Lordship? 24, 25.
Yes.
Yes.
25. Read 25.
Yes, 25. As is expected, an offence under section 307 is indeed a serious offence. However, from the narration of the petitioner as to how the incident occurred, there was an element of provocation on the part of the victim who had thrown the card of the petitioner to the bushes. The existence of fray tempers cannot be ruled out, and in the heat of the moment, the alleged altercation must have taken place. Therefore, prima facie, it will appear that the act of the petitioner was not premeditated or with the intention and knowledge that the same will cause death. 26 or so is relevant here. The fact that the whole episode resolved around family member who had thought it is prudent to settle the matter by way of the compromise deed will also have the impact of proceeding before the trial court. Therefore, where is an all probability.
When this compromise was recorded, what is the date of compromise?
Compromise is 21st.
And on which date the complainant was examined before the court? Before the trial court?
Complainant is before the compromise.
What is the date? You should have brought it in the record. Very difficult for this court. Because the decision of the apex court will be binding on this court. Even if court wants to give you relief, cannot do it by travelling beyond. Synchron is the main obstacle.
Well, they can produce the evidence from the trial court.
Yes, but then whether the purpose will be served or not, that is the main thing.
And moreover, the my lord,
There is no other option. You bring it on this thing. That is the only option.
Yes. If you allow, we'll bring the.
No, we'll pass an order. You do it. We thought we can dispose of the matter, but then. This court is not very sure at this stage, especially when evidence is recorded by the court, whether to rely on 161 statement or not. In line with that Lakshminarayan case.
Yes.
Okay, Lakshminarayan says basically speaks up to the stage of filing of charge sheet. The apex court said that yes, in such a situation, if High Court desires, High Court may look into all those evidence collected. But then your case has proceeded further. Okay, so in that view of the matter, the relevance of 161 statement and other evidence, so far as the charge sheet is concerned, will not be of much importance at this stage. The evidence will basically take place of the primary thing to be considered. Is there an administration gone?
Yes, my lord. Especially the doctor's evidence will be important. And the doctor which my learned friend has referred, he is just a Caesar witness.
Then again another thing comes, you see.
Different doctor, my lord.
When the matter is at last stage, will it be proper for this court even to rely on the evidence and to pass some order here? Basically it will be a kind of, short-circuiting the trial. These are the two situations which you have to encounter. That is quite difficult. Best recourse is wait for the outcome of the trial of the case. If you say that there is a compromise and if there is nothing damaging your
Your Lordship, there's instruction that the trial court insists defense witness now also. Insists to bring defense witness.
Anyway, then you'll bring on record those evidence then. You just bring on record the evidence recorded. But even then, this will be kind of easy, kind of interference with the trial. Yes, what happens if we pass on order basing on this 161 statement in terms of this
Entire exercise, my lord,
case?
entire exercise which has been done by the trial court, my lord, that will. My lord,
No, but then the court permits. That's how Apex Court has permitted that.
Yes, my lord. It can be done. My lord always has the right, the power to exercise.
The question is not of exercising right by the court. Whether court is, it will be lawful for the court to do it or not. That is the main thing.
When the entire trial has proceeded and it is at the last stage, my lord.
Your evidence was recorded before the compromise.
Yes, record. But now the court has insisted accused to bring defense witness. It seems that
that is okay.
Let's see.
That is all right. We do not know what should be correct course at this stage.
Your Lordship may allow to that we will bring additional affidavit on this.
No, it's okay. You can bring it. You can bring it. Anyway, you bring it. I do not know what purpose it will be served or not. Mr. Sinkan will come with some other plea at that point of time. So that is what he is thinking. Yes, sir. This is prayer meet. On prayer meet. Comma. The petitioner is allowed to bring on record the evidence recorded by the trial court in connection with this case. With regard to the injuries, with regard to the alleged injuries sustained by the complainant stroke respondent number. Your respondent number?
Number 3, Your Lordship.
3. Here in respondent number 3 here. Just read the line. What it says. With regards to the extent of alleged injuries. Did you say by filing an additional affidavit? What is it? Last. By filing an additional affidavit. By way of an additional affidavit. Stop. The learned assistant PPAPN for the paragraph. Learning assistant PPAPN for the state has no objection. Prayer allowed. List after 2 weeks. You do it. See what happens. See, try your fate. Not very sure. You should have undertaken all those exercises by now. Matter would have been over. Maybe
that we, by relying on the compromise kit, we.
No, that is okay, but then the very decision which you are relying upon, that speaks about, you see, like examination of the nature of injuries.
Yes.
So that was needed for you to establish before this court. And especially when you know that these compromises come after the evidence is recorded. That was the proper course you should have adopted. Now Mr. Sinkon is waiting for the opportunity. Yes. No, wait.
Obliged.